we can get started.
Go ahead, Johnny.
Welcome, everybody. This is our first webinar. Big thank you to Paula Tapia, to Sam Rodriguez, Tara Willis, Jamie Circle, and Vanessa, who really worked hard to put this together and do this really nice. And actually, the presentation looks beautiful when you guys see it come up. We partnered with three wonderful attorneys, business partners, Knighten Parlow, Adams, Stirling, and Epsten, for this educational webinar. We're going to have special appearances by our furry friends. And hopefully we'll learn a little bit about best practices in the community. And at the end of this, everyone gets to vote on our furry friends that we're going to see: canines, felines, and I believe there's a turtle as well. So, okay. All right. Mark Dodge, would you like to talk about Animal Samaritans a little bit?
I would love to. Good afternoon, everybody. Some of you many of you probably don't know that aside from the HOA thing I do on a daily basis, I'm very actively involved with the Animal Samaritans here in the desert. I'm one of the senior board members. I'm the vice president of the board, and I have been working with them for some 3 years. I serve with Dia Frank, who's an attorney at Epsten, Grinnell & Howell as well. The organization is a wonderful organization. We not only have low-cost clinics, we do school education programs, we do animal-assisted therapy, we do any of a number of things revolving around just education, and we have an adoption center as well. And we are in the process now of, before this all began, of a capital campaign to raise money to build a new adoption center. And frankly, the one we have is 40 years old, and it's a dilapidated old building. So very good organization. I'm very proud to be a part of it. And that is why oftentimes you see my name affiliated with Animal Samaritans, be it our golf tournament, who they're usually a benefactor of, or any of a number of other things that we do as a company. And we, of course, all love our pets as well. So it's a natural fit for us. We have pets in the office almost on a daily basis. We have a cat that used to live in the office, although maybe for a brief period of time. But anyway, it's a very active organization. So there is some benefit today from this seminar for not only the animal theme, but also some benefits for the organization as well. So thank you all very, very much for logging in and participating, and hope you find it worth your time.
Okay. All right, Kieran, you're up first. Would you like to introduce yourself and
Absolutely. For those of you who are tuning in expecting to see Dia Frank here today, don't adjust your set. Dia was not able to join us, but I'm going to do my humble best to fill her shoes and talk with you for a few minutes about electronic board meetings and some best practices that some of you may have already mastered now in the last couple of months, but for those of you who have not, hopefully we can help you get to that point. We're going to talk about some of the different platforms that are out there to use. Some of the legal requirements that you need to comply with, even though you're not having in-person meetings, some challenges you might encounter along the way, and then some strategies for helping you deal with those challenges when you do. Okay, a number of different platforms out there. By platforms, I'm not talking about the technology for like a Zoom or a GoToMeeting type of thing, but just different conduits in which you can communicate. Teleconference is something generally many of us have participated in with, maybe not in the context of a board meeting, but maybe in your day-to-day work. Video conferences, you may not have heard the word Zoom before March, but now it's become part of our daily vocabulary. And then in a smaller context, you have the ability to meet via email, and we're going to talk a little bit about that in a minute. So before we get into those specifically, I wanted to just go through a couple of definitions. The Civil Code defines a board meeting as a congregation of a quorum of directors to hear, discuss, or deliberate any item of business that falls within the authority of the board. And then it talks about in 4090B of the Civil Code, it defines what a teleconference is. And it says it's a quorum of directors connected by electronic means and through either audio or video. So for our purposes here today, or in the civil code, when you see the word teleconference, just think that that includes either a video conference or a telephone conference. So it covers both. It goes on to provide that a teleconference meeting, so again, audio or video, shall be conducted in a manner that protects the rights of the members. So think the Open Meetings Act, the whole idea, transparency, allowing the members of the community to participate in the governance of their community. So that's a core tenet of the requirements, regardless of whether you're doing an in-person meeting or a meeting via technology. And then it goes on to say that except when you're having a meeting that's solely an executive session, you have to comply with all the corporate formalities. So even if it's an electronic meeting, you have to post notice, post your agenda, conduct homer forms, all the things you're used to doing in a traditional in-person meeting. One other requirement, it says, and this is something we're going to talk about in a little more detail, it says that except for when you're meeting solely in executive session, the notice of a meeting is supposed to indicate, or excuse me, notice of a telephonic meeting is supposed to indicate that there's one physical location where a member can attend and listen on the meeting, and that one director or another person designated by the board, frequently a member of the management team, is designated to be at that location. As you can appreciate in our current health considerations out there, that's not a great place to be. At different times, the state has forbidden people to gather in large groups. Your county may have slightly started to modify that a little bit, but even if you can, probably not a great idea to do that. And so what do you do if you're faced with that circumstance? Well, some of you who are really keep up to date in politics may know that in mid-March, Governor Newsom actually suspended portions of the Brown Act, which is sort of the granddaddy of the Open Meetings Act. It deals with public meetings for city council, school boards, and that type of thing. And one of the portions of the Brown Act that was suspended was this specific requirement about in-person meetings. And so you may have seen that your city council or your school board or others are meeting electronically. And so the question that has come up a lot in the last couple of months is that something that you can do in your community? Well, as you can appreciate, the virus is traveling at a rate far faster than the law can keep up with. And so that although both CAI and CACM and others have petitioned the governor to extend that suspension of the Brown Act to the Open Meetings Act, it's under consideration. They haven't said no, but they haven't done it yet. Nonetheless, many practitioners, including our firm, have reached the conclusion that we would much rather face a lawsuit from a member saying that, gosh, you didn't comply with Civil Code Section 4090 by having a board member located on site during their Zoom meeting, then if you get sued by a bunch of members who allege they contracted the coronavirus by attending an in-person meeting so they could participate in the governance of their community. So that's one way to look at it. Certainly consult with your management team and with your legal counsel before you do that inside of your community, but that's one way to approach it. The other venue that you can conduct a meeting is by email. Some of you may have already done this because it's been an opportunity to meet for a while now, but remember it's under very limited circumstances. Civil Code Section 4910 provides that a board shall not take action on any item outside of a board meeting, but then it gives you an exception. It says that you can conduct a meeting via a series of electronic transmissions, so email in the parlance of the legislature, if all the directors have agreed in writing that you can conduct a meeting in that manner, and then a written consent of that, written evidence of that consent is included in the minutes of that meeting. But it's under only very narrow circumstances. It's when there is an issue arises that could not have been reasonably foreseen, that requires immediate attention and possible action by the board, and it was not practical to provide notice. So very narrow circumstances. So more likely during the course of the current health issues, telephonic or a video conference or a combination of those two will be how you'll be meeting. Okay, what are some things to keep in mind when you're conducting meetings? And I apologize, I know some of you probably are old hands at this, but some of you may not have had that opportunity yet. So I'm speaking a little bit at an entry level to begin with. But Primarily the first person, like today, Sam's super clued in on technology, and IT person, as well as a manager with DRM, and he's very knowledgeable about how to conduct things, because at some point today, there may be some issues that arise. And so someone either participating in the meeting or someone who is attending the meeting may have some technology issues. So the host should be someone who's familiar with the technology and helps troubleshoot when those type of issues occur. And then in an unlikely event that a disruption occurs, I know that would never happen in any of the meetings we've ever attended in our lives, but if that happens, the host has the ability to kind of take control of the meeting and try to restore some order. What are some ways you can help yourself do that? Well, you can establish a password. You may have seen in the media a couple of months ago when Zoom and other electronic meetings first started, that there was some famous incidents where, whether it's a classroom or other types of meetings where people Zoom bombed. They jumped into the meeting and they acted inappropriately or used inappropriate language. And so having a password will help protect you from having that occur in one of your meetings. Another way you can address it is by having a waiting room. And so that when people first join the meeting, they sit in the waiting room and the host actually has to let them attend that meeting. That generally when they do, it varies a little bit from the different host platforms, but they have the ability to write in your name or provide some sort of way to identify who you are. So if the host looks down their membership list and doesn't recognize that person, you have the opportunity to reach out to them and ask them who they are, and then you can verify that they have the ability to enter the meeting. And if so, you let them in. If not, you don't have to let them in. Oftentimes, you may have some folks who are unable to participate in the video portion, but they can dial in. And so you may just see a number, and that may not be a number on your list, so you can ask them those questions. But again, having the host control who enters the meeting from the waiting room is a really good thing to do. One other thing you can do is lock your meeting. And that's something you probably would only do with your executive sessions, because homeowners tend to come and go during the course of the meeting if there's just a certain portion of the agenda that they want to participate in. So you might not want to lock an open meeting, but that you can lock it so once you have your directors and management team and whoever else is coming to your executive session, you can lock the meeting so no one else can attend. Like with an in-person meeting, you want to have some business rules about how you're going to run that meeting. For example, like John did earlier today, said we're going to go ahead and mute everybody's mic with the exception of the participants. That way, if someone is typing or multitasking, that way it doesn't disturb the actual meeting. So a good business rule to adopt. You can talk about how someone will participate in a homeowner forum. You may ask them to just raise their hand. Oftentimes there's a digital format where you can raise your hand as well. Or you might do it more like many in-person meetings where you ask individuals to sign up. In this case, it might not be on a piece of paper as you enter the room. It might be in an email that you send to the manager and say, I want to participate in homeowner forum. And then the board or management team member would say, okay, Mr. Smith, your turn. They would unmute that person's mic and they'd let them go ahead and participate in it. So there's just some business rules you might consider adopting. You also might want to have some disclaimers, and you may already do this with your in-person meetings if you've had someone surreptitiously record them. A lot of times you see on the agenda an admonishment saying that the board does not authorize the meeting to be recorded. And then oftentimes the board president will say at the beginning and end of the meeting, just to protect it in case somebody's surreptitiously doing that. So it may be a good idea for you to do that as well. Just announce that it's not, you're not allowing it to be recorded. And then finally, that if someone is acting inappropriately or disrupting the meeting, like with an in-person meeting, you would ask that person to leave. Here you have the advantage of the host can essentially mute their mic, or actually ultimately remove them from the meeting if they're being disrupted. Managers and board members are pretty good at dealing with unexpected circumstances because that comes with the territory. And so that certainly may have already happened in your experience running a telephonic meeting, but if not, it probably will come up in the future. So be prepared. Technology is great when it works. There's that old adage about not working with children, pets, or technology, right? So we got 2 out of 3 involved today, so we're really tempting fate. But that it's always good to be prepared and have a backup plan. A great example is what John did here today. If you look at the agenda, it has the link for you to join via the GoToMeeting, but it also has a telephonic option. So if for whatever reason we lost the ability to participate with the video portion of this, everyone has a dial-in number. So, that's a great example of how you can be prepared and have a backup plan and disseminate it to the membership. Remember that you have a wide variety of folks participating using different types of technology. Someone's got a brand new state-of-the-art laptop. Someone is using a 15-year-old tablet. People have a variety of different speeds to their internet. They have different other issues that are going on. So try to present the meeting in a way that anticipates that you may have folks who are dealing with other challenges, and be prepared as the host to help them troubleshoot if they have those type of challenges. It'll save you from some frustration and save them from some frustration. If they're, like I mentioned before, a great idea John did on the front end, muting everybody. I think that's something that comes up a little more when you have the larger group you have. There may be somebody multitasking and typing, that type of things. Hopefully it doesn't happen just amongst your board, but sometimes it does. And so you want to try to cut down on the background noise, because it makes it difficult for folks to hear what's going on in the actual meeting. Practice with the platform you're using. If this is your first GoToMeeting, that you don't want to be the host. You don't want to be the one conducting things. You want to participate a couple times and feel comfortable with it, so that if something does go wrong, you feel confident in your ability to address it going forward. Well, that's all the material I had today. I think Dan is coming up next. Thanks for your attention.
Thank you very much, Kieran. Okay, Mr. Parlow, you're up next.
All right, thank you, John. My name's Dan Parlow, and I am the quiet one at Knighten Parlow. I assume many more of you know my business partner, Michael Knighten, than you know me. As he likes to joke, I've been social distancing for about 30 years. We are a firm in Palm Desert, and we're about 1.5 years old. We focus primarily on advising and representing HOAs. Before that, I've been practicing HOA law almost exclusively, well, not majority time, for about 10 years. Before that, I practiced liability defense litigation, basically fighting against personal injury claims and car accident claims and other sort of contract claims. And that leads into the topic today. Best practices essentially related to considerations in reducing liability to owners. 2 really important words in that topic are considerations. We have 15 minutes, not 15 years. So this is nothing meant to be comprehensive. And the key word is reducing liability. It's California. It's a ton of law. There are a lot of creative lawyers out there that will find a way to file some sort of litigation that may or may not have success. So there's no way to eliminate liability risk. And real quickly, another title of this could have been the best practices for suing an HOA. For those of you who know me, you might know that I spent about 3 years on the dark side representing owners in cases against HOAs. Yes, I was an HOA ambulance chaser, but what we're going to go through today is a very brief roadmap of how I analyze every case that I considered that came before me. The first thing to consider is that there are really sort of 4 primary sources of liability when you're dealing with owners. The first one, I just call it bad actions, and we're not going to spend a lot of time in this, but this is intentional conduct, wrongful, it's targeted at an owner, no good reason. A couple examples I've seen is a board of directors or a manager getting together and getting somebody's car towed improperly. I've actually handled a matter where my clients had 8 or 9 security cameras focused on their front door where nobody else had security cameras on them. The HOA was clearly just targeting them for no good reason. Another one that has come up in cases where an HOA is targeting an owner for having too many books in his house and calling it a fire hazard, even where the city had actually done an inspection and said, there's no fire hazard, it's fine. The HOA just had a problem with this one particular owner. Basically, if you're functioning as a director or a manager with a vendetta, the court is going to find a way to find you wrong. But again, that doesn't happen very often, and those are some extreme examples. The next area is written law, and that's a huge body of law, basically anything in writing. You have all heard of Davis-Stirling Act, obviously. You've probably realized quite a bit on it too, and that is just barely scratching the surface of all the written law that can be applicable to HOAs. Everything in the entire country, from the US Constitution all the way down to the city ordinances, can potentially apply to HOAs. At the federal level, we have the US Constitution, we have the federal law that is adopted by the House and the Senate, and then we also have federal regulations by different agencies of the federal government. You know, one example that comes up a lot in HOA law as far as federal law is the Federal Fair Debt Collection Practices Act. As far as federal regulations, even though it's not formal law, there's a lot of regulations that still apply. One that I've dealt with recently is the FCC has a regulation restricting what an HOA can actually do with respect to satellite dishes that are present in exclusive use common area. Basically, you can't do anything. And again, it's a body of law that you typically don't come across unless you've had to deal with it. In California law, we have the California Constitution, we have the state law that's been passed by the legislature, and then we also have state regulations, again, adopted by administrative bodies within the state. And I'm originally from Wisconsin, and we have in Wisconsin, it's a 2-volume section called Wisconsin Laws, or Wisconsin Statutes. In California, there's probably 100 or so volumes of our actual written law, and I would say probably 1,000 or so volumes of our state regulations. It's really kind of insane, the amount of written law by our state. Some of the ones that probably come up a lot in HOA are the Rosenthal Fair Debt Collection Practices Act, which is a state basis for putting liability on debt collection. And then another one that is pretty common is the Fair Employment and Housing Act, state regulations meant to prevent discrimination in housing. You go one step lower, you have county and city municipal codes and ordinances. Those can deal from anything with signs to property maintenance requirements and restrictions. And how, even within that, you have to go a little bit deeper and find that the city or the county, whichever approved a housing development, may have put conditions of approval on the tract map, which are things that carry over with the HOA and have to be complied with while the HOA is in existence. And then something that's kind of new in the past 2 months that we've been learning a lot about, and it's not new, it's just it hasn't been as prevalent, is there are executive orders, there's proclamations, emergency orders. These are all things that typically aren't considered part of the law because they haven't gone through the lawmaking process. They haven't been reviewed or subject to judicial review as to whether they were adopted properly. But in the past 2 months, this has become a very hot topic in trying to deal with HOAs as well. And I'll put this out there that many of these laws, the written law, when we're talking about the written law, many of them are written in a way that almost incentivizes lawsuits. In a way, it incentivizes ambulance chasers. There's no real need for damages sometimes, and then oftentimes there's awards of attorney's fees if you have a successful case. So if you as an HOA fail to provide documents within a timely fashion to an owner who requests it and there's no good explanation for it, even if it was a relatively minor document that nobody cares about, there is a way for a lawyer to get involved, an ambulance chaser, file a lawsuit, and try to get attorney's fees out of it. So something that could seem pretty minimal is almost, by some of these sources of written law, been turned into major situations. Now, one thing about the written law, a lot of it is subject to how the courts then interpret the written law. They'll either clarify it or they'll add some more example situations that allow you to understand it. So despite what we have the legislature writing one thing, the courts may come in and actually sort of modify that slightly. Now, technically, they're just interpreting it, but you can always find different exceptions. The next area of a primary source of liability is what I call negligence. It is the situations where the definition of negligence is when you cause damage to someone else and you did that through not acting as a reasonable person would have acted. If you breach a duty to act reasonably as a board or a manager and you cause concrete damages to the homeowner, the homeowner has a right to recover damages. Now, it really is, you must have done something in a way that a reasonably careful person would not have done, or a reasonably careful board or manager, or you must have not done something that a reasonably careful board or manager would have done. If you fail to do something, or if you do something that's improper, it can get you stuck on negligence liability. Indeed, there's another way to do it where if you as a board know of a certain risk to your members and you don't warn your members of those risks, even the failure to warn can be deemed negligence and can expose an HOA to liability to members. In this negligence concept, it's a really amorphous thing to where a lot of it you just have to go with your gut. It's really fact intensive. The facts are always changing, and it's always somewhat subjective because you never know how a judge or jury is going to view the decisions on whether the HOA was acting reasonably. As to the fact intensive part of it, numerous times managers have called me to ask me questions about what they should do, and we go through a discussion. They're like, Dan, all I wanted was an answer, and all you gave me was 20 more questions. It's because when we're trying to look at all the various factors of what can actually be negligent actions, there are a ton of facts that go into that decision, and we'll have some examples pretty shortly on that. And again, it's always somewhat subjective based on the judge. And the final way that is a primary source of liability is the governing documents. They are contracts between, in many respects, they are contracts between the HOA and the members. And a failure to comply with a requirement of governing documents can lead to liability for the HOA with the owner filing a decent claim. What I want to do next is go through some example situations of how these all sort of apply. I'm trying to pick a wide types of cases to kind of go into. And one of the first steps to know is that in a civil courtroom where people are trying to evaluate liability, the burden of proof is always on the plaintiff, or in this case, the owners. So by default, an HOA is walking into court presumed innocent, although many times that presumption goes away fairly easily. The first example fact pattern I want to talk about is a water intrusion claim. This is usually more in condominiums where the HOA has responsibility for the roof. But let's take a hypothetical of where there's water intrusion from a roof damage and it goes into an owner's unit and there's damage for property. Again, there's typically no liability, or not typically. By default, there's no automatic liability for an HOA. You have to go through the steps to try to figure out, is there a way to get them on liability? Unless the HOA or a director has been up there hammering a hole into the roof, there's no bad action issue. Typically also, there's no legal issue. Roof maintenance, some of it's legal, but there's no law that says HOAs must maintain a roof that never allows water intrusion. So from that, you have to go to governing documents and negligence. So in governing documents, even if we assume that the association has maintenance, repair, and replacement obligations for the roof, a one-off or first-time example of water intrusion does not automatically mean that the HOA was negligent. If you have first-time water intrusion and the HOA, as a reasonable board, being advised by a reasonable manager, had no notice that there was going to be a water problem at this particular place, it's likely not going to be found negligence. But if you start having situations to where this was a second, third, fourth water intrusion into this particular unit from the roof, or even into a different unit, which should have led a reasonable HOA to know that the roof had some problems, that's when you start getting into negligence liability. Another thing would be if a roofing contractor came and said, hey, that roof is really old, and that could be a roofing contractor, that could be your reserve inspector, your reserve study consultant, saying, hey, that roof's pretty old, and roofs don't normally last that long. Just by telling you that, if the reasonable board doesn't then do further investigation, that can lead to negligence. Now, even when you do have negligence or don't normally have negligence, CC&Rs can do things that will modify that. For example, some CC&Rs try to incorporate water damage exculpation clauses. Those are sometimes effective, but if an HOA is still ultra negligent in its, or significantly negligent in allowing things to happen, they will be found liability. There's no perfect immunity. There's certainly no right to stick your head in the sand. Some CCNRs also have roof inspection requirements. If those are violated, that might lead to a finding of breach of CCNRs or negligence. And then finally, there's a case out there where the CCNR said the HOA must maintain the roof in a first-class condition. In that circumstance, the HOA was found liable even in a first event water intrusion situation. So these are all considerations that go into whether you, essentially, if you have an HOA ambulance chaser, things that they might be looking for on behalf of that owner. The next case example, it's an alligator case, but since we don't have alligators here in the desert, I went with coyotes as well. But there's a relatively famous HOA case out of Georgia where a woman was in fact killed by an alligator. Is the HOA, and she was inside of an HOA, is the HOA liable for that? Usually no. But in this case, and in fact in Georgia, they determined that the HOA wasn't liable. But I guarantee you that the case I'm talking about, if it would have been set in California, the HOA would have been liable. And there's two key factors in that case. Of course, there was no bad action. Nobody trained the alligator to go after the woman. There's no specific law that says a HOA in Georgia or here in California has to keep alligators or coyotes out of the property. But in that HOA, there was a very specific operating rule that said that the HOA will inspect, monitor, and seek out any alligators longer than 6 feet and remove them from the community. The alligator that killed this woman was 8 feet long. In that circumstance, now Georgia, again, on a split, 4 judges versus 3 judges said not liable. I almost guarantee in California that would have been a liability. If you have an operating rule that says you're going to patrol and remove coyotes or alligators, you're in trouble if you don't comply with that rule. The next thing that I'm going to go through real quickly is balconies. This has been a really hot topic since SB 326 came out, enacting Civil Code 5551 at the beginning of the year. That's a pretty basic statute that talks about you do need to do an inspection of your balconies or other elevated structural components every 9 years. I would argue that, in fact, you need to do that far more than 9 years in order to comply with negligence, especially if there is something that indicates that the balconies are going bad. And the interesting thing about balconies is even if it's member responsibility, which a lot of CCNRs will change balcony responsibility to member responsibility, the HOA still would have a duty to protect the people underneath the balconies in case they collapse. To where the HOA would have to make sure that the area is being taped off, or even call the owner with the negligently maintained balcony to a hearing. There simply is no way to escape total liability by shifting responsibility to the members. COVID-19 in pools, I saw that Adrian will be talking about that, so I'm going to skip real quickly over that. 2 real quick things about the COVID-19 in pools is the facts always change when you're doing a negligence analysis. There might be one analysis if you're just trying to comply with the governor's orders or the municipal orders. There's an entirely different and new and updated analysis if you find out one of your members who has been using the pool has COVID-19. And the other thing that I want to point out about COVID-19 is, political debate aside, any position that COVID-19 is irrelevant, is a hoax, is not as bad as it seems, will never stand up in court. Our courts have been closed for over 2 months because of COVID-19. The courts will not accept a decision that COVID-19 is not something to be taken seriously. So after all of this analysis, we really have some very key best practices. And the first one that I didn't put on the slide is, because I'm assuming that everybody's doing it, but the first and most important thing should be all bold, all caps. Do not ignore problems. Ignoring problems leads to liability. Because while HOAs have broad discretions to do various investigations, to take steps, to consider money, putting their head in the sand is not one. So if in this, your best practices are typically always consult with counsel. Whenever you're looking at something, always understand that there are multiple pathways to finding an HOA liability. And the final thing is, realistically, this is California. There's tons of lawyers. There's tons of law. Nobody ever knows enough law to fully protect an HOA. Nobody can predict judges and juries, and you can't prevent stupid lawsuits. Even stupid lawsuits get their day in court. So you really have to accept the inevitable, know that your HOA is going to get sued, and then tender it to your insurance because hopefully you have some protection. And so that is my best practices.
Thank you very much, Dan. Very informative. Next up, Adrian Adams.
Hi, everybody. I think most of you probably know who I am. I've been writing a lot of newsletters lately and covering the whole coronavirus issue. So we're going to talk about two topics here. One is how to pay your bills. This is going to be important for board members and managers alike. And then opening the facilities. So let's go to the next slide. The whole thing of the coronavirus, hitting this is completely unprecedented, shutting down the entire country overnight and throwing, it's now 39 million people out of work. That impacts homeowner associations, and the association boards have obligations that they need to meet, yet they're trying to figure out how to balance that against people who have been thrown out of work through no fault of their own. And so boards, obligations on paying their bills, dealing with just common area maintenance, the utilities, management, insurance, professional services, that would be CPAs and attorneys, and contributing into reserves. So how do they meet those obligations when suddenly there's an impact on their cash flow? And the thing about the shutdown of the economy is that it doesn't immediately impact associations. There's a delayed effect involved. And so the economy starting up again as it's doing right now, it's restarting, is not going to immediately fix the problem for boards on the cash flow. They're going to continue to experience these problems. The owners who are thrown out of work, the first thing they're going to do is stop paying their assessments, because they're going to be wanting to use that money to pay their mortgage or to buy groceries. So assessments are probably the first thing to go. And we're going to see this exacerbated starting July 1, because the $600 per week additional monies kicked in by the federal government for those who are unemployed will stop. So we're going to see another drop in income for people who are on unemployment. And it's going to take a while for everybody to get back to full employment. So the board needs to meet its obligations and figure out how to do that with reduced cash flow. So let's go to the next slide. There we go. Okay, so the things that boards have to deal with is that associations are nonprofit. They have zero-based budgets. That means there is no excess money, and that's by design. So that means if their assessments drop, they need to figure out how to either get more money or reduce expenses or both. And the board's obligations, their fiduciary duties to the membership as a whole. So being compassionate in dealing with the individual owners is one thing, but their primary obligation is to the membership, and that means paying the bills. So boards, by statute, they're required to levy assessments sufficient to perform their duties. If you go to the next slide, there's also case law. Okay, that under Park Place versus Neighbor, that assessments are essential to associations to function, and without them they can't meet their obligations. And so owners have an obligation to pay their assessments, but here we've got a situation where we have owners who are suddenly not able to through no fault of their own. So the collection tools that boards have available to them, late charges and interest, assessment liens, foreclosures, and lawsuits. What is it that boards can and should do with these collection tools? Let's go to the next slide. Okay, so a lot of the questions I was getting through the newsletter were, should they across the board waive all late fees and interest for all members? And I don't think that's a good idea. You should continue to impose late fees and interest, because then you can use those to bargain with someone who is out of work, who is delinquent in their assessments. And what you want to do is waive those in exchange for payment plan. So get them on a payment plan. It provides incentive for them to get on a payment plan, and then to stay on that plan if they want to keep the late fees and interest waived. And the other thing that you're going to want to do as boards and managers working with boards is ease the payment plan standards. Whereas before we might have had some pretty strict standards for someone who's delinquent, here you might want to ease some of those standards to make sure that they can pay so that once they get back to work, they can pay their existing assessments plus pay off the ones that they were delinquent. And one of the things is, what about lump sum settlements? So assuming someone is delinquent 3, 6 months, 9 months in their assessments, and they're suddenly able to come to the board and say, okay, I'm willing to pay them lump sum, pay it all if you discount them. So they want a 10, 15, 20% discount on the assessments that are owed, the delinquent assessments. Boards can and should consider taking that option. So provide some kind of discount, because money in hand is better than spending money on legal fees, chasing it, hoping to get it. And getting that money in the door will help the board then in paying their assessments. Okay, what should boards avoid? Well, waiving assessments. I got a number of people writing in to the newsletter saying, shouldn't we just waive all assessments? Or I'd get a variation. Shouldn't we waive assessments for everybody who's out of work so they don't have to pay those assessments at all? Well, that puts a burden on those who are paying the assessments. And if you waive all assessments across the board, how in the world are you going to pay your bills? So the idea of waiving assessments is just a bad idea. It just doesn't work out. And there are other things that boards can do other than waiving assessments. I got questions about should they just not record any liens? And again, because people are thrown out of work through no fault of their own, and they're expecting that they will go back to work. Well, the problem is you don't know necessarily that they will ever get those jobs back. A lot of the restaurants are never going to reopen. They're permanently out of business. A lot of the retail stores, like JCPenney's and others, declaring bankruptcy and closing stores across the country. So there's no guarantee that the person will get their job back. And the lien protects the association. It preserves your rights. So in the event the person, for example, declares bankruptcy, it again protects the association. So recording liens is something that boards should be doing when owners become delinquent. And then the other question I was getting, should they forego all collections for now, just stop all collections? Well, you've got a lot of people who were in collections before the pandemic ever hit. We've got an owner in one of the associations we represent who was delinquent starting in January of last year, hadn't paid any money for over a year. And then the pandemic hit, and she said, well, do I have to pay anything now? Since the pandemic, shouldn't you waive all of my delinquencies and not pursue collections? My response is no, we continue with the collections against those older delinquencies, because the board's obligation is to try to bring in those monies so that the association can pay its bills. Let's go on to the next slide. Okay, so one of the sources of monies that are available to boards and by statute are the reserves that you're allowed to borrow for short-term operational needs, unexpected expenses, unexpected shortfalls. So that money is available for borrowing, and boards can. And if they do borrow from the reserves to handle the short-term cash flow problems, they're required to follow steps set forth by statute. And that is giving notice to the members putting a resolution in the minutes regarding the purpose of the borrowing and how the board plans to repay those funds back into reserves. And they're required to repay them within 1 year, or the board can adopt another resolution extending that if there's good reason for extending it. One of the things that boards need to be careful about, and managers that you need to be mindful of to remind boards, that if they decide that on certificates of deposit they're not going to renew them because they may be laddered, they're becoming due, available, and so they don't roll them over. And they roll that money into an account there in the bank, into the checking account or into reserves, is that if you exceed $250,000 in combined accounts with a single bank, not a branch, but the bank, so that would be Wells Fargo, for example, then you're not covered for anything in excess of the $250,000. So if they have a $200,000 CD coming due, they let it mature, they roll it into the account, and they already have another $200,000 sitting in operations account. They're well over the $250,000 limit, and they're not insured. So what you want to do as managers, make sure that you alert boards to that, so that they can move a portion of those funds into Bank of America, open up an account there, or another one of the other banks. Okay, let's go to the next slide. Probably a better approach than borrowing from your reserves is to temporarily reduce contributions into reserves or to stop reserve contributions altogether. So whatever amounts of money that you're putting into reserves each month, you can, with a resolution again in the minutes, reduce or stop those contributions. There is no statutory requirements dealing with reduced or stopped funding. Interestingly enough, there is no particular requirements on boards. Although there is a disagreement, kind of a split in the legal community, is stopping the contributions deemed a borrowing? Because this is money that you've already told the membership that you're going to be putting into reserves, and suddenly you stop doing that. Is that then borrowing? And then you need to go through the process. Well, if a strict reading of the statute says it's not borrowing, because it's actually money that's already in reserves and you're taking them out of reserves, that's borrowing. But I would treat it with the same level of notice as you would borrowing, which is giving notice to the membership, a resolution explaining in the minutes why you're stopping your reserve contributions, and then what it is that you plan to do to replace those funds back in or contribute those funds back into reserves. Let's go to the next slide. Okay, and this is, we're going to talk about briefly opening of the amenities. And I've been, if those of you have been following in the newsletter, not real happy with the conflict that we've got between the state and the counties on this issue of opening up swimming pools, for example. And as of last night, the city or the county of Los Angeles is opening up their swimming pools. And they're specifically saying that these are deemed not public pools and that they can open them. Now, that may be because the state continues to declare all pools to be closed and all public pools. And other counties have not taken that step of declaring them not public or specifically cutting them out from the public pool definition and opening them. So we have some counties that are in conflict with the state's closures, and you've got a lot of associations that are opening their pools and other facilities per the county's allowances, but contrary to the state. And for those in Riverside County, which DRM works with those in Coachella and elsewhere, a lot of them have already opened their pools per the Riverside. And Riverside allowed them specifically, and then I heard there was some backpedaling that Riverside has then since said per the state, and of course the state has said no. So there's a lot of confusion reigning out there on what can be opened and when. And they're, I think, scheduled for stage 3 counties, but no counties are yet in state. So I don't know how this is going to work out, but it creates, as Dan was talking about, this potential liability where you've got in violation here, not of a statute, but of an executive order. So the opening's contrary to executive order. Even though there is potential liability here, I'm not sure that there's anybody really going to be suing their associations for opening contrary to the state orders. We have more people threatening to sue their boards for not opening the facilities or threatening to withhold their assessments because they don't get to use the facilities. And that's not something that they can do. They can't withhold their assessments, not legally. So, you know, what risks do the boards face? There's potential that there's not going to be any insurance coverage for the, you know, someone who catches the virus and claims that they caught it from the pool or the gym or the clubhouse, because there are typically exclusions for communicable diseases in the insurance policies. So there may be no coverage for that. The plaintiff, though, is going to have difficulty establishing causation, that that's actually where they got the virus was from the association's facilities. But nonetheless, if the lawsuit's filed, as Dan has probably pointed out or will, that the association has to defend it. And they may be defending out of pocket because the insurance may not step in. So boards that are opening up their facilities, they want to be careful that they closely follow published guidelines for opening their facilities. It reduces the risk of potential liability. Another is getting side hold harmless agreements. I don't know that the hold harmless agreements would stand up in court. They're certainly going to be challenged if somebody wants to file suit, but it creates a barrier, another barrier for the plaintiffs to overcome. So it doesn't hurt to have them signed. And I know a number of associations are currently implementing them. So the right now, the whole thing dealing with opening up facilities is just a huge ball of confusion. It's a mess. And boards, and it's very fluid, it's moving very quickly. I was very surprised to see Los Angeles County, who's been a big holdout, suddenly folding on this issue last night and opening up facilities. I expect to see other counties quickly following suit. Next slide. I think this may be my last slide. Sam, let's see what we got. Okay, so I think we're ready for Q&A section. So John, I'll turn it back to you.
Hi. Oh, thank you very much. I have a question here. It says, what if the association is in the middle of a special assessment collection? Should they suspend that during this time?
Who's that directed to?
And any one of you guys. So I guess they're asking, what if an association is in the middle of a special assessment collection? Should they suspend that during this time?
Well, it depends what the assessment's for. If it's a critical assessment, they need the money to deal with some repair that's going, if they don't repair, it's going to lead to additional damage and or mold issues. If it's water intrusion, then certainly they want to collect the money, they want to make the repairs. So it just depends what it's for. If it's something that they can put off, they can delay, they can defer the maintenance or whatever the issue is for, then certainly they can.
Okay.
On to the pets.
So thank you guys all for being our wonderful speakers for the day and agreeing to this out-of-the-box webinar. here's our out of the box part. We have our best in show pet contest. And, you know, the reason when John and I were first talking about this, the reason we went for this concept was because so many of us are sheltering down with our pets. So hopefully, you know, we were able to make a good connection for those in attendance and for the people that submitted photos. So what we're going to ask you to do, we're going to show the first slide, which I believe is canines, and in the chat box,
Okay, so we will go through here and figure out to go through all these. We'll figure out who the winner is. Paula and I will get in touch with the winners, and they get a gift card. Also, one of the great things too is that Desert Resort Management and our business partners, the 3 wonderful attorneys who came today, there will be a donation of $1,000 to Animal Samaritans. So thank you very, very much.
That's very kind.
Thank you, everyone.